Ms. Sheeran, you're here for the 222649. You'll have to unmute yourself, ma'am. And then Mr. Lem, you're up here also for that case.
Thank you, George. Merry Christmas.
Merry Christmas. Happy holidays.
Sorry, I'm sorry, Judge. I was having some troubles with my phone.
All right, Ms. Sheeran. So we're on the record in docket 2202649. That is Crystal Sheeran versus James Lem. Will the parties please introduce themselves to the record?
I'm James Lem.
Okay. And ma'am, you are Crystal Sheeran?
Yes.
All right. This is the time set for a formal hearing for non-payment in this matter. I'm going to briefly inquire of Mr. Lem. Mr. Lem, you had a pre-trial on October 26, 2022, in which a video was showed for the various aspects of getting a lawyer. You are not represented by counsel today, is that correct?
Yes, sir. I was denied.
Okay. And so this is the time set for formal hearing. Have you had the opportunity to speak with Ms. Sheeran concerning some of these matters? Or is it your intent to go forward with the hearing today?
Go forward with the hearing today.
All right. Ms. Sheeran, is it your intent to go formal with the hearing? Go forward with the hearing today?
Yes.
All right. All right. The standard is preponderance of the evidence. You just saw kind of how we do it here. Ms. Sheeran, you have the burden of proof. Crystal Sheeran, as the landlord or representative of the landlord today. Did you want to testify today?
Did I want to testify?
Yeah. This is the set for it's time for formal hearing. So you need to provide me with all the evidence that you'd have in making the allegation against Mr. Lem concerning his non-payment.
I sent you a letter, Judge. Did you get it?
I did. So
you pretty much just want me to tell you why I want to cancel the land contract?
Yeah, for the formal. So you want to cancel the land contract. The letter is not a part of the evidence. So did you want the letter marked and admitted as part of the evidence for the formal hearing?
Yes.
All right. So I did get the letter. Have you seen that letter, Mr. Lem?
No, sir.
All right. I'm going to take this opportunity to have the letter from Crystal Sheeran marked by Wendy, and then we'll show it to. Yeah, why don't we make a copy? Let's make a copy of the letter, because what's in the court file is not necessarily part of the evidence of the hearing, Ms. Sheeran. So we're just going to make sure that this formal hearing has all the evidence associated with it.
Okay.
So let's make a copy of it, and we'll be back with you. All right, and we'll have that marked as plaintiff's exhibit 1.
Your Honor, can I speak?
You sure can.
Do you have the original documents from the
I
first
do have the
hearing?
complaint, the initial complaint you filed. The letter was not a part, since you're going to be speaking about the letter, I figured it was best to make it an exhibit.
Okay.
All right, so Ms. Sheeran, let me swear you in before you testify. I'm going to have you raise your right hand. Spell your last name for me, ma'am.
Sheerin.
All right, Ms. Sheeran, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, and you are Crystal Sheeran, and you live in Winston-Salem, North Carolina.
Yes, sir.
All right, ma'am. Tell me the nature of the allegations for the land contract, the forfeiture of the land contract, ma'am.
Yes, he forfeited the land contract because he has not paid the taxes, which was stated in the land contract, and also he's been behind multiple times for rent to own, and
So what years did he fail to pay taxes for?
2019, 2020, 2021, 2022, and I have the amounts here right now. I just got done paying to save my house just recently, a couple days ago.
And and since then, which is a part of the land contract to pay the taxes, you indicated that he was to pay a certain amount of land contract rent per month in order to stay in the residence or the house.
Yes.
And how did he do it? When was the date of the land contract agreement?
It
Is that
was
April
July
12th?
12th.
Go ahead. July 29th?
Sorry, hold on. I just want to look at my old papers.
All right.
It was April 12th of 2020.
Okay, April 12th of 2020. And how much was rent supposed to be a month?
It was supposed to be $650.
All right. And was Mr. Lem able to pay $650 a month since April of 2020?
He does pay the $650, but it's always past the due date.
That's due date. And what is the due date pursuant to the land contract agreement?
So the land contract it was the due every 12th.
Okay. And you would receive payment, you would just receive payment late.
Yes, sometimes it would be on times, but most of the times it would be late.
All right. And but payment is up to date on this matter up until December of 2022.
For the land contract, payment is not up to date. He did not pay July and August for the land contract agreement.
What?
Did not pay July and August concerning the rent?
The
$600?
land, he did not pay of July and August of 2022 for the land contract agreement, but me and Mr. Lem made a verbal agreement of a new contract, which was rent month to month. But since he wanted to proceed with the hearing, I no longer want him, I no longer want to rent to him anymore.
All right. So the month to month, what was the new month to month payment supposed to be?
$700.
So your testimony today is that he's been in violation of the land contract agreement in regards to late payments and failure to pay taxes, which is a part of the lease, part of the
Yes,
original agreement for the years 2019, 2020, 2021, and 2022. Do you have a total amount in that regard?
I do, sir. It is $4,419.72.
$4,419. And how much?
And 72 cents.
Okay. And was the land contract supposed to was supposed to go up until the time of the purchase price of the agreement to sell, which is $43,000?
Yes.
All right. Anything else you want to tell the court, Ms. Sheeran?
No, not that I can. No, not that I can think of, unless you want to talk about the letter that I wrote you.
No, I made it a part of the exhibit, and I'll read it for the record. Okay. I'm writing to you a summary of what has been taking place between me and Mr. Lem. I started a land contract property of 826 Clayton in 2019. Mr. Lem has been struggling to make the payments. Since the very first payment, he's never paid me on time. This went on for about a year and a half. I was understanding as much as I could. Then I got notice last year the taxes were behind and that the house is going into foreclosure. I talked to Mr. Lem numerous times about paying the taxes. When he finally made a payment, it was the day before foreclosure day. After that, I talked to him and asked when he will get the taxes paid. He said he does not have the money and he didn't know when he would have the money. I explained to him that the contract states the taxes are to be brought current or he will forfeit the house. After going back and forth, he accepted that he would not be able to pay them and he would just rent the house out. When then made a completely different agreeing statement, he would pay $700 deposit and $700 of rent. I filed paperwork and noticed the court date was months away. He tried to cancel the new agreement we had, tried to come up with money soon after the court date. I spoke to him and asked him about the new agreement we had and why did he disagree in court. He said it was because they gave him another court date, so I'm going to try and come up with the money. So honestly, I believe is not being able to come up with the funds needed to bring the balance up to date is just wasting my time at this point. The house is now back in foreclosure. He has not made any attempt to make a payment on taxes. I'm just ready to terminate this contract. I want him out of the house. I've received complaints from neighbors about drug trafficking, loud music, cars parking in the wrong place and blocking their driveway.
Wow.
I'm just tired of the confusion and the broken contract. I'm moving forward. I'm asking court to terminate the contract. Sincerely, Crystal Sharon. That's the nature of the letter that was written to the court.
Yes.
All right. And Mr. Lem, you have a copy of that?
Yes, sir.
All right. Mr. Lem, did you want to provide evidence to the court today?
I would like to. I have no evidence, but I'd like to speak.
All right. So I'm gonna have you raise your right hand. State your name and spell your last name for the record.
My name is James Richmond Lamb.
Okay.
Lemm.
All right. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, Mr. Lem, you can make your statement to the court.
All right. I'm gonna address. I have told her when I was gonna pay it, when I could pay it. I told them I filed my income taxes. I know I got plenty of money coming. I'd pay it all off then. And they said they would. For one, I never have talked with her. I always talk with her boyfriend. I never had a conversation with her about this house. Nothing. So this is all a lie. She never called me. She never said nothing. I talked to her man. The reason why I agreed, the reason why I gave him the $700 for the month on September is because I got approached at my house. 3 fellas came over and told me I'm gonna come up with some money right now, or they're gonna throw everything out the house. And he said, well, just give me $1,000 right now and we be good. $1,000 for rent, $700 for the $700, and then $300 for deposit, whatever. My kids was right there. They was all loud and stuff. I wasn't trying to fight nobody on my front porch about no rent because I have 2 houses, and I always pay my rent. I don't always pay my rent on time, but when I don't pay it on time, I always give them the late fee. The late fee is only $25. I have gave them $75 for late fee every time. I'm not understanding, and it's never more than a week late. So the bill was the agreement was $25. I give them $75. I put $8 grand into this house. I only owe about $19,000 or whatever onto it. I can have everything paid off by the first week of January, February, March when I get my taxes. Every dollar, and I don't owe them $1. I gave them extra money. I gave them $1,000. I gave them $1,000 on September. And then I gave him, and then the next October, I gave him $800, an extra $100. So I gave him, and then plus I gave him an extra $50 each month, and they changed it to the first. And then twice I had people come knock on my door and threaten me. Not once have I had a conversation with this lady. Not once have I told her I didn't know when I was coming up with the money. Not once have I had no drug trafficking at her house or nothing like that. That's what I'm not. Like, people have parked in the wrong driveway, and I went over and I apologized to the lady. But no drug trafficking. Ain't nobody even there but to do drug traffic. Never had the police call to that house, nothing. So I don't even know where. I guess the drug trafficking sounds good to them.
Do you have any exhibits you'd like to admit to the court today?
No, Your Honor. No, I do not.
Do you have any witnesses to testify on your behalf?
No, I do not, Your Honor.
You understood today was the date for a formal hearing?
Yes, I
in which
do.
we were providing
Yes,
evidence. Did you pay property taxes in 2019?
I wasn't even there in 2019.
Did you pay property taxes in 2020?
Yes, I did.
Did you pay property taxes in 2021?
No, I didn't, Your Honor.
Did you pay property taxes in 2022?
No, Your Honor. No, I didn't, Your Honor.
All right. Ms. Sharon, any rebuttal on your behalf?
No, he did pay a one payment in 2020 2020, but that wasn't even enough to take it out of foreclosure.
So I'm going to rule, the standard here is a preponderance of the evidence. And I find that the plaintiff has met their burden by a preponderance of the evidence that the defendant has been in violation of the land contract agreement indicated by late payment and the failure to pay property taxes on at least 2 occasions. I won't count 2019, but I will count the 2020 and 2022. And therefore, the land contract has been violated pursuant to the agreement that was made. And so, Ms. Sharon, the only thing I can do now is you're going to have to provide. So you've met your burden of preponderance of the evidence. The land contract is now forfeited. So there's no land contract that's given up by the defendant's conduct. You're going to have to provide me with an order to sign to make that effect happen. Okay. Okay. I can't. It doesn't happen because I rule on it. It happens when I sign the order, and then there will be a date. So without the land contract set, there will be a date of eviction as a part of that. And that'll be 11 days from when I sign the order, I believe. 10 days. I think a land contract, it's 10 days from the date I sign the order that the address, and so just so we're clear on the address we're talking about, and I'm doing that pursuant to the signed agreement from the seller, Crystal Sharon, and the buyer signed agreement on April 12th. That's James Lem. Both signed, and the property is 826 Clayton Avenue, Lansing, Michigan. Is that correct, ma'am?
Yes.
All right. If you follow that up with an order, I'm saying that because Mr. Lem, you're the one who's under the gun. You'll have 10 days after that order to find, at least to make that property turn possession over to Ms. Sheeran, okay? All right. Anything else for the record in docket 22-02649? Ms. Sheeran?
No, I have nothing else.
Okay. Do you need the email address, or do you need a contact number in order to make sure that you have the right order to sign that you submit to me?
Is it the same phone number to the courthouse?
It is. I can give you the civil department's number of 517-483-4426.
Okay, so it is 517-483-4426.
That's correct.
Okay.
All right. Anything further on the file, docket 22-02649? Ms. Sheeran?
That is all. Thank you, Your Honor.
All right, Mr. Lem, anything else?
So I'm sure she's gonna have it in. So I'll have to be out by the second week of the next month, right?
Yeah, I'd say that the 10th is just any time around the 10th is going to be 10 days later. So you're playing with that number. You're playing with that date. All right. All right. That's all for the record. 22-02649. Thank you for your appearance, both of you.
Thank you.
Thank you.
Wilson and Brown property versus Katie Evans.
Yes, Your Honor. Good morning.
All right. Good morning. We're on the record in docket 2203-877. That's Wilson and Brown property versus Katie Evans. Will the
Cody.
parties please introduce themselves for the record.
Yes, Attorney Chris Brown representing plaintiff.
Ma'am, you are, oh, sir, I'm sorry. You are Cody Evans?
That's correct.
All right, thank you. This is the time set for a motion on the case. Looks like it was initially defaulted, and then I granted at least a hearing on this motion to set aside the judgment. So this is your motion, Mr. Evans. I haven't indicate here that I was unable to reconnect the proper time for the hearing. I did log in at 8:30, which I thought was my time, but I was told it was 10:30. Be able to have a proper hearing as trial household founder. All right, so Mr. Evans, at this point in time, you were not here pre-trial. Have you had the opportunity to speak with a legal representative in this matter, Mr. Brown?
With Mr. Brown or for myself?
Well, it's your motion, and you're indicating that you had technological issues as to why you were not here at that time.
Yep, that's correct.
So I set it aside. So what I'm wondering now is if Mr. Brown is amenable, would you be willing to speak with Mr. Brown concerning this case?
Me and him did step into a breakout room, and he said to go ahead and ask you any of my requests.
Go ahead and say it again.
I said, me and Mr. Brown did just step into a breakout room, and then he just said to ask you my requests.
All right. So for technological issues, so I understand the nature of your motion, Mr. Evans. Mr. Brown, do you have a response?
I do, Your Honor. It seems like he was, when he was able to log in, was he there at the court in person or was he on Zoom?
I think it was a pre-trial was on Zoom and he logged in, and then he says he was told it was at 10:30, which resulted in a default. I called the case at I called it at, it was 10:50, it was scheduled for 10:15, and I called it at 10:56, it looks like. But I tend to be I tend to be a little lenient because I understand that the Zoom hearings, people have trouble getting in at times on Zoom. I have it scheduled for 10, it was 10:30, not 8:30. So there appears to be a problem in that regard.
Yeah, that was because
I guess my only question would be, did Mr. Evans try to even call the court or do anything in any way, shape, or form? Because obviously he has a telephone, and let the court know that he was having trouble logging in at any
I don't have any record.
Later that day, the next day, any time. Because I guess my position would be, step one would be, was there good cause not to attend the hearing? And then if that hurdle is actually jumped, then the second would be, does he have a meritorious defense? This type of case, Your Honor, is simply a possession only after the lease is expired. The items addressed in his motion could be possible defenses if there was a money claim. There is not a money claim on this. The only defense to a termination case after the lease is expired would be, hey, the lease is not expired, I have a lease, or
right,
I have a lease extension. That is the only defense to this type of case. There is no other type of defense to a termination case when that termination is based upon a lease expiring. As the law does not require, obviously, the law does not require the tenant to sign a lease agreement. And therefore, it also does not require the landlord to sign a lease agreement extending the lease. There is no such law. So there is no meritorious defense, even if a good cause is established, which I would argue good cause is not established, because obviously, if you have trouble logging in, you take it to another step. You call the court. You come in person. You call the court the next day. You call the court 2 days later, at any point in time, which obviously was not done in this matter. So I'd ask that the default judgment stand. In my communications with Mr. Evans, he did indicate that he was moving out and that he just simply wanted some additional time. I would indicate to the court that his first notice to quit was sent to him in July 29th. So this is not a surprise, asking him to move by the end of August. Then the plaintiff waited another 2 months trying to get him to move out and didn't even file the case till November. Now here we are at the end of February, Your Honor. So there is no surprise on this termination case when it started on July the 29th. Thank you.
Mr. Evans, your response?
Yep. The initial thing was me and him did have an agreement to have him pay me to move out, which was something that we were going to do. And the
So you've got that in writing?
I do have that in text.
All right. That's not. So when was your lease up, Mr. Evans?
We had switched back to month because I had a 2-year lease and then it went back to month to month, I believe in August.
All right.
Your Honor, there's a lease agreement in the file. The lease expired on July 31st, 2020. So 2.5 years ago is when the lease expired.
Mr. Evans, did you make any phone call or did you contact anybody in the court after you failed to appear? I'm just curious.
No, that's when I was having the phone issues with that because my phone, I ended up having to get a new one. I have a brand new 14 now because my old one had fallen and I have that cracked one. I mean, I can show you guys if you guys want to see that one. It's all destroyed. And so I had an issue. I had to go into Verizon, go get a new phone. And that's when I contacted legal aid. That's when you were asking if I had regard to talk to a lawyer. I didn't get to like have one because of my income. So they weren't able to help me. But they did advise me some things, and they told me that to file a motion because that there was going to be a default placed in regardless. So that I had kind of talked to them and was kind of listening to what they were going through, and then filed that motion. Just kind of try to get back with them. Know what I mean? Because they take 24 hours to get with you. On top of that, to even file, like to even hear anything from them, to know what was kind of going on from that point.
All right. Anything else, Mr. Brown, on Mr. Evans' motion to set aside the default?
Nothing, Your Honor. Thank you.
All right. Mr. Evans, I'm going to deny your motion based on the evidence that I've heard and your motion. I'm going to deny the motion to set aside default.
Can I explain to you why that the whole thing to pay to move out was not accepted?
It doesn't matter. I'm denying your motion to set aside the default at this time. I don't find because of your lack of contact to the court, which I mean, you're not only late on that day, but after February 1st, we never heard from you until you filed the motion on February 10th. You never contacted the court to indicate why your presence wasn't here, why you failed to appear on that date. And then Mr. Brown makes a good point on the second indication is that this is a lease that has run out for months, and you're indicating now that the place was somehow not inhabitable. I'm going to deny the motion to set aside the default, so the default continues to be granted. Mr. Evans, you're going to have, so Mr. Brown, you're going to follow, have you followed that up with the paperwork already? I think you have.
I have not.
No, you have not.
I have not filed the writ yet. And obviously I'll be filing the writ today. However, I will not be, I will give Mr. Evans through the weekend to actually move out, because obviously I want him to keep all of his stuff. I don't want to do an actual eviction. I don't want to incur the costs, and I'd like him to leave on good terms. And I will give him all the way through the weekend to actually move out as well.
Okay,
But I
so
would like to have that writ signed so that I'm not filing it next Monday, which is a week from today. I'll have it in my hand next Monday so that we can actually do the eviction if need be on Monday without the need to come back to the court. Thank you.
all right, so the court will sign the order once you follow up. Mr. Evans, you've been given a grace period indicating Mr. Brown. So you have, it's hard to argue. You haven't had notice of this since this was filed so long ago. But I think Mr. Brown's giving you through the weekend to get your stuff out and then find new lodging. Okay.
Mhm.
All right. Anything else for the record in docket 2203-877? Mr. Brown, I'll await your order and I'll sign your writ. Mr. Evans, your motion set aside the default has been denied. Anything else on this record, Mr. Brown?
Nothing, Your Honor. Thank you.
Mr. Evans, do you understand what we've done today?
Yes, Your Honor.
All right, thank you. That's all for the record in 2203-877. Thank you, everybody, for your appearance.
Sam, you are the sole owner, member, managing member of Sam Rental LLC. Is that correct?
Yes.
And Sam Rental LLC is in the business of leasing residential real estate. Is that correct?
Yes.
And as one of the properties that Sam Rental owns and leases is 3140 Fielding Drive in Lansing, is that correct?
Yes,
And that's within the city of Lansing?
yes.
Now, I have here, if I may, Your Honor, do I have,
You want to have that marked?
yes,
Okay.
please.
So I'll have that marked as plaintiff's exhibit 1.
It's 3104, not 3140. 3104 Fielding.
First of all, ma'am,
I'm sorry.
you can't say anything or we're gonna ask you to leave, all right? All
My
right.
witness.
Do you understand?
I understand. I just wanted you to have the correct address.
All right. He'll have the chance to correct it, okay? And Miss Becker's gonna have a chance to cross-examine him, all right? But what we can't do is have people in the back yelling out whenever they want to, all right?
This is about the record. It should be right.
So there's plaintiff's exhibit 1.
Thank you, Your Honor.
You're welcome.
Sam, I'm now showing you plaintiff's exhibit 1, which appears to be a residential lease agreement, a total of 4 copies. And would you please identify that for me, confirm what it is, and maybe give me a little more detail as to who the lease is with?
Sure. This lease is between Sam Rental LLC and a tenant Deborah Wilke. And the property address 3104 Fielding Drive, Lansing, Michigan 48911. And the lease was a month to month, starting from January 1st, January 1st, 2022. It's a month to month lease.
Okay, and now, if we go to the last page, the 4th page, there appear to be what I would call electronic signatures on this lease. Is that correct?
Yes.
And can you identify for me, first of all, who has signed it as the landlord?
Yeah, landlord is signed by me.
Okay, as Representative Sam Rental LLC, is that correct?
Yes.
And what is the date of your signature on that
On
lease?
the 12/23/2021.
And then there appears to be a signature by DocuSign for the tenant. What is the date of that particular signature?
It's a 12/23/2021.
And whose signature appears on that?
That's Deborah Wilke.
Now, I'm looking at that signature, and that signature, although it's not terribly easy to read, does not appear to say Wilkie.
Yeah, she changed her last name a few times. I don't know, once while during the lease, she married and she divorced. That's what now. Yeah.
Okay, well, Sam, first of all, let me just ask you this. Would you agree to me that it appears to be Becker as the last name here, D. Becker, as opposed to it being D. Wilkie? Would you agree with me on that?
Yeah, I agree with that.
Okay, but be it Wilkie or Becker, the tenant to whom you lease the property to is the woman here in court sitting at council table. Is that correct?
Yes.
Okay. Now, I believe you indicated that this is a month-to-month tenancy according to the terms of the lease, correct?
Yes.
Now, did you provide Ms. Becker Wilkie, did you provide her with notice of termination of your tenancy?
Yes.
And do you recall when that was?
That was in around August or July of last year.
Do you happen to have a copy of the demand for possession or a notice to quit in your file here?
Yes, that's in my file.
If I may, Your
You
Honor,
may.
if you could please pull that out for me.
And we'll have that marked. so you want this marked as People's Exhibit 2 or Plaintiff's Exhibit 2?
Yeah, yes, thank you, Your Honor.
Okay. All right, so this has been marked as Plaintiff's Exhibit 2. I would counsel both the witness and not to hit the mic as it ends up reverberating on the headphones.
Okay, very
So,
good.
Yeah, so yeah, the mic is right there on top. So if you hit it,
Yeah.
we're not able to record you.
I've got you. Thank you. Your Honor, first of all, I'm not sure that I offered for admission Plaintiff's Exhibit 1, the residential lease agreement. I would offer that at this time.
Okay, motion to omit Plaintiff's Exhibit 1, the lease. Any objection?
Yes.
Okay, what is the
Not my
nature?
signature. Your
What,
Honor.
it's not your signature.
It's not.
Okay, I'll allow you the opportunity to cross-examine on it with that understanding. Plaintiff's Exhibit 1 is admitted into evidence.
Sam, I'm showing you what has been marked as Plaintiff's Exhibit 2. Is that the demand for possession that you had served terminating the tenancy?
Yes,
And does it indicate when it was that you served Ms. Becker?
on the 8/1/2022,
And what was the method of service?
the first class.
Okay, very good. Your Honor, I offer Plaintiff's Exhibit 2.
Okay, so motion to admit Plaintiff's Exhibit 2, which is the notice to quit to that listed as Deborah Wilkie and all occupants, 3104 Fielding Drive, Lansing, Michigan, 48911. Any objection, ma'am?
No.
Without objection, Plaintiff's Exhibit 2 is admitted into evidence. And then I'll look at Plaintiff's Exhibit 1. I don't have that.
Oh.
That's the document that was just
Yes, Your Honor, excuse me. I took that.
all right. Thank you. You may
Go.
proceed.
Sam, since the time of serving the demand for possession on the defendant, which again was August 1st of 2022, have you received any rent from the defendant during that period of time?
No,
So you have not received rent for the month of August, September, October, November, December, and January. Is that correct? Now, who do you understand is currently residing on the premises at 3104 Fielding Drive?
I think her daughter, and she told me she's living 1 or 2 days over there.
So well, here. So first of all, you say her daughter. I assume that's Ms. Becker's daughter. Is that correct? Do you know what her name is?
I think Alicia.
Okay, and so you believe that she is residing in the residence. And did I understand you to say that Ms. Becker would stay there on occasion?
That's what she told me, but I never seen it yet.
Okay. Is anyone else there residing there to your knowledge?
No, I don't have knowledge.
Now, during the period of time that you have leased this property to Ms. Becker and it's been occupied by she and apparently her daughter and maybe others, has it been kept fit for its use that was intended?
Yes,
Has it remained habitable during that period of time?
yes,
You believe that you are entitled to possession of this property based upon it having been leased to Ms. Becker on a month-to-month basis, and you're having provided her with notice of termination of that tenancy. Is that correct?
yes.
I have nothing further, Your Honor.
Thank you. Okay, so you can ask the witness any questions that you'd like. Just place them in the form of a question.
Sam, did I or did I not, back in August, when you wanted to jump the rent $150, tell you If there were windows broken by a little boy around the corner, that he was mad because he didn't babysit him anymore, my daughter didn't babysit him
So
anymore.
so just one question at a time, but there's like three
Just
questions in that.
question.
But there's three questions in that.
Okay.
Just one, ask one
Were
question.
you informed that there was a little boy who broke out 3 windows in the house? Plus the easement window. Were you informed, yes or no? And
Not-
you said, oh, excuse
Wait,
me.
hold, let him answer
I
the,
need to finish
let
the
him answer the question. Were you informed that there was a broken window from a neighborhood kid?
No, she didn't.
Your Honor, that's a lie.
Okay,
Reason I'm saying
ma'am, just ask the questions.
Okay. We called you and told you that once again. the
Okay, that's
front-
not a question.
Okay.
You're making a statement.
I don't know.
You're gonna have you're gonna
How
have
can I
plenty
say
of
it?
times to make statements,
How can I
okay?
say it?
What,
I need a phone call. We
what
need
you
a
want to
phone
say
call.
is a statement.
Ask him a question.
So you just need to ask a question.
Were you not informed that there was 1 2-bedroom windows, the easement window, and the front window again had been broken by this little boy? And you said that his father.
No, not what you said. Just ask him. Were you informed of that? Were you informed of that, sir?
No, not she.
Okay, so he's saying, the answer is no to that question. Okay, next question.
Were you not told by the, what do they call the inspector? To have the things that I gave them and the things that they
Wait,
inspected in the
now let's
house.
be specific. What,
Okay,
let's be
Put on a
specific.
new, he finished a new room in the back.
Okay,
as I was
so,
looking at
so
3
no,
3
just
months
give me
after-
one item, ma'am.
Oh, boy.
Do you have a list of items?
Oh, yeah. in
Okay,
my
where?
head. In my
Where?
head. Oh, they were right there on that phone.
I can't take exhibits on a phone.
All I can do is tell you then.
Okay, so ask him. I ask him as a question.
Did the inspector or did the inspector not tell you to take that hose out of the wall that was running across from the dryer and over around to the iron board and take the iron board out and follow into the kitchen where it ended up? Did you take it out or not?
No, he didn't tell me anything.
He said, he indicated he was not told about the hose.
Well, as I was standing right there, just happened to- Did we call you and ask you if and tell you that the roof was leaking in Atiana's bedroom and there was black mold down the wall?
Uh.
Did we not tell you that the furnace wasn't working? Did we not tell you that the?
Wait, let him answer,
He
let
said
him,
no.
let him answer the question. So they did not tell you the furnace wasn't working.
Did we not call you not too long ago, it's been a couple months, to tell you that the toilet wasn't working again? And you said that you were not sending a plumber?
Okay, do you have any of this in writing? Any of these requests in writing?
No, because we talk on the phone.
Okay.
I have to talk.
Do you
to
have
on the
any
phone because I don't
evidence?
text
Do you
much.
have any evidence today that would
Only them
suggest?
pictures. Only them pictures, my daughter.
I'm sorry. I know I can't speak. Can I say something? to
She's
her?
my witness.
You can consult with
Okay.
you can consult with your daughter.
Come the maintenance man to the house. But I can't answer
Yes.
that. What about the duct tape on the AC?
Did you or did you not come to the house with the maintenance man and look under the kitchen sink where you guys cut a big hole, which is now why it's mouse ridden, and you duct taped it on? Oh my God, I'll get the maintenance man.
Ma'am, so
I'm trying to remind her. I'm the
Right.
one who's saying that he knows that he's under the house all the time.
you can't talk, okay? You can't testify, okay?
That's
So
what
the-
they told her.
She can, but not when it's her time to,
Oh, okay.
not just anytime she wants
Oh,
to.
okay.
No, I'm just
Sorry.
trying to refresh her memory. I'm sorry.
Did you? Okay. Did you or did you not put a new dishwasher in, but it was improperly installed and it has not worked correctly since?
We put a new dishwasher that was working fine.
So they put it, the response to your question is they put a dishwasher in and it was working fine.
For about 3 days.
Is that a question?
It worked for about 3 days, Sam.
But is that a question, ma'am? That's not a question.
Okay. Did we not tell you that it worked for about 3 days and that for some reason, just like the other one, it was plugged?
He didn't tell me.
Yes, I did. I don't know how to tell. He's just gonna deny everything, so I don't know what to keep on going.
All right, you can, your witness can take a can give a statement on your behalf, all right?
Okay.
Do you have any further questions for this witness?
No, because he's just gonna tell me no.
Any redirect, Mr. Now?
No, Your Honor, thank you.
Right. May this witness be excused, Mr. Now?
He may.
All right, this witness is excused. Sir, you're free to leave the witness stand. Mr. Now, do you have any further proofs?
No, Your Honor, I do not.
All
Thank
right.
you.
Does the plaintiff rest?
We do.
All right. Miss, you preferred Miss Becker, correct?
Yes.
Miss Becker, do you have any proofs today? Do you have any witnesses that you'd like to take the stand?
My daughter,
All right, so let's call her to the stand. What's her name?
Alicia Wilkie.
Okay, Miss Wilkie, you can come up. Once you get on the stand, I'm gonna have you take off your mask for recording purposes,
That's
okay? But I'm gonna have you state your name and spell your last name. Come on up here. All right, and your first name is?
Alicia,
And how do you spell that, ma'am?
ALEASHA,
Okay, and your last name?
Wilkie.
And how do you spell?
WILKE.
Can you have you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, I'm gonna have you have a seat right here. Now, for recording purposes, I'm gonna have you take off your mask so we can record you. And just be mindful that that's the recording device. So if you hit it, it doesn't record anything, okay? All right. Ms. Becker, you may proceed and you may have the witness, you can ask him questions.
Ms. Wilkie, is this or is this not my signature? Yes. That's the exhibit.
All right, so you want to
Compared to that
you want to admit this as an exhibit?
Yes.
All right. And so I'm gonna have this marked as defense exhibit 1. All right. So it's been marked as defense exhibit 1. Did you want to move for the admittance of it?
Yes.
All right. Any objection to the?
No objection.
Okay. Without objection, defense exhibit 1 is admitted into evidence. I'll keep that for now. Ma'am, you do understand that if there is no lease, then you're on a month-to-month anyway.
I understand.
Okay, thank you. Just so we have the law right.
Okay. Ms. Wilkie, did you at any time speak with Sam about the heater, the furnace not working this year?
Yes, in person.
And this was when?
End of October-ish.
And what was it that he said about fixing?
He didn't say anything. The next person I spoke with was the maintenance man. He had the maintenance man for a very short period of time. He's the only person that came and fixed anything. Mr. Sam was there and documented everything that needed to be done, including the furnace, broken windows and everything. He was there in person.
And was there any conversation between the two of you about him fixing it or not fixing it? Was there at any time him telling you that he was not going to get the windows fixed?
Yes, he said I would have to get the window fixed because I knew the kid, which didn't make sense because the whole neighborhood knows the kid and I wasn't the only house with broken windows. And I'm a renter. Why would I have to fix the window?
Because the little kid got mad at you?
Yeah, but he did it to multiple houses. So even I just assumed it's because he was mad at me.
And did you ever have a conversation with the boy's father about them paying for the windows?
I made a police report and I gave the police report document with the docket number to Mr. Sam's maintenance man. When Mr. Sam came there, I also showed him the same thing. They took pictures of it. I told him that the police department told me that as long as it was under $6,000, that he wouldn't have to pay for a lawyer and he could charge the little boy's parents or sue the little boy's parents for the window. In person, I spoke with them and the maintenance man, a black guy. I wish I could remember his name.
At any time, when we first moved there, at any time was there an inspector that came?
A city inspector, yes.
Was he or was he not told to take, what do you call it? It was a plastic pipe above the washer and dryer. It went through and came around to where the iron was at and somehow went down through the wall into the kitchen. Is that true that she told him to take it out?
Yes, along with multiple other things that were supposed to be fixed.
Was he or was he not supposed to at that time fix the deck in front?
Yes,
Had it been fixed in front?
no, the maintenance man that I just spoke of before is the one who fixed it. And he just fixed that, and I want to say it was October when I met this maintenance man. And after he fixed the few things that he fixed at the house, which was the first time my air conditioner had ever been fixed, the roof was the gutters were ever blown out. I never seen the man again. It was like he did too much work and was fired.
At any time, was he notified of the molding coming down the wall and the rain that had been coming in Oceana City?
Multiple times. And that was a brand new room that was built on 6 years ago when we moved in, which had no reason to be leaking. It's because it wasn't put together properly.
And because of his not listening, did he or did he not, when he was informed that he was told that the wall was being destroyed
Yes,
between the two bedrooms?
yes,
And has he been to fix it?
no,
Are there many, many things that were supposed to have been fixed and he never came back and had them fixed?
yes, it should have been because before,
This big, okay, this big hole that's under the sink was not there when I rented that home. Is it there?
yes.
And the maintenance man did what?
Taped it, duct taped.
And the mice ate through.
That's under both bathroom and kitchens.
We never had mice.
Just ask the question.
Yeah, you're being given a lot of leeway here, so
I understand.
just,
I
she's under oath,
Yes,
she's
sir.
testifying, you're not testifying, so.
She might be before.
I have Parkinson's. I got a lot going on in my head.
Okay. Well, I don't know what you expected was gonna happen today. We
I'm-
set it for formal hearing,
Yes.
so
understand.
this is the time that the court,
She had a hold of the paper that he had. sent.
well, just so you know, that, I mean, you were given notice from
I understand. that,
December
Your Honor.
14th,
I
that
understand that,
this
Your
is the
Honor.
time set for a hearing.
When in August, when Sarah stopped paying the rent, did he automatically jump the rent?
Well, when Sarah stopped paying the rent, she paid for the 18 months when they stopped paying the rent, he came to me, not my mother, and told me he wanted $12.50 a month rent. And I told him absolutely not. I wasn't paying $12.50 a month rent. We were never evicted in August. We didn't get an eviction notice until November. We've never had an eviction notice before that, ever. We lived there 6 years, always paid rent, never had an issue until he tried to up us to $12.50. And I said no.
Did rent begin or not begin at $9.50?
Yes,
And at a point when I was foster parenting your children, did he or did he not up the rent then? And said because it would cost more.
Just
Wait,
answer the question, you can't do
yes.
that. Yes, the 10.
Was it because he said it would cost more for electric and gas?
Yes,
Is that my problem?
No.
Okay, have we ever been evicted?
no,
Has he always received his rent prior to Sarah,
yes,
since Sarah? Up to August.
yes,
And did I or did I not tell him I was not paying $12.50? And did you not tell him that?
yes.
That's it, Your Honor.
All right. Any cross-examination?
No, Your Honor, thank you.
Okay. May this witness be excused? Without objection, this witness is excused. Does the defense have any further proofs?
No.
Does the defense rest?
Yes.
All right. So I'll hear any argument you have concerning this matter.
Your Honor, I don't believe any valid defense was raised here to the termination of tenancy. Again, according to the terms of the lease, it was a month-to-month tenancy. Even assuming for a moment that the lease wasn't valid because of an inappropriate signature or something, then as the court rightly pointed out, we're still on the month-to-month tenancy at that point. Clearly, demand for possession was properly served on the defendant tenant. And now we're finally here today to make that determination as to whether or not the tenancy was terminated. I would like the court to find that it was indeed, enter a judgment of possession for the plaintiff, and accord the defendant and any other occupants of the property their 10 days to vacate the property.
Thank you. Response?
The only response that I have is, isn't it or is it not against the law to forge my name?
I'm sorry, ma'am.
That is not my signature, sir.
Okay.
That is not my signature.
Okay. So this
Everything
is
I
all,
sign, I sign
this is
Deborah
all
and
part of
Becker.
your argument.
I
which
signed
is-
Deborah and Becker, everything I signed,
Okay,
and I have perfect penmanship. My
okay.
mother was a school teacher. Sam and I have had many conversations, Your Honor, many. And he knows, he knew exactly what was going on at the house. He knew exactly what was wrong with that house and did not come to fix it. He would send a maintenance person every now and then. But the last one that he sent was the only one that really, really did what he was supposed to do. So, I mean, I'm saying, I'm not disputing that the rent's not paid since August. I'm not disputing that whatsoever. I'm simply saying that he's supposed to do what he's supposed to do per the city as well. And the city told me when I called the inspectors, they told me that he had called them and told them that they had been taken care of.
Your Honor, just so the record, I'm sorry, just so the record is clear, we're only seeking a judgment of possession, not a money judgment.
Correct.
Only a
That's fine.
judgment of possession.
That's fine.
Anything else for your summation, ma'am?
How many days we have?
I haven't made a ruling yet,
Well, I'm requesting 15 if I can get 15.
but
If I
wait,
get 15
wait till my ruling and then,
Oh,
okay.
Just saying.
Wait till my
I've never
ruling.
done this before, ever.
I know, it's okay. I understand that that this is a new arena for you. However, I must indicate for the record that you were explained that we're going to formal hearing, bring all your evidence, bring it away, the court can see it, it's tangible, so we know
I
it,
understand
you
that.
know, and so that's what I'm making my ruling on, what's in front of me.
But what
It's
makes
the only
me-
choice I have.
Your Honor, what makes me so mad is I was told by another landlord, take your phone with you
Right.
that has all those pictures that you've already.
I
showed
would
me.
suggest that you don't get your information from other landlords, okay? Maybe talk to a lawyer, okay? Maybe talk to a lawyer.
Well,
In
I'm
this
not gonna have to
regard,
go through this again.
in this regard, the law is clear that if a signature is contested, which this seems to be contested, then I'm supposed to look beyond the document. I do have a signed document lease. The fact of the matter is that even if this lease doesn't exist, you're on a month to month. You're on a month to month.
And
So
that
you're
brings me to another point,
you're
sir.
30 days to 30 days legally, okay?
That brings me to another point.
Well,
He said,
I don't know who he is, and I don't,
Sam.
and at this point, I'm only talking about the law. I'm not talking about other people and what they told
I
you.
was told it was a 2-year lease again.
But you could have been told anybody,
Just
I'm
listen to
not.
the
yeah,
judge, okay?
and you probably shouldn't, you probably should get your information from somebody who knows the law, okay?
I-
So you, regardless, you're on a month to month. And what's required in a month to month, whether it's signed or not, is a notice to quit, which is valid. That's valid, August. And you have not paid months since then. And you've indicated that you refuse to pay months since then, you know, and that means that your non-payment of rent is going to get you evicted. All right. If you had come in court and indicated that this is not habitable in some way, that I can't live here, and brought proof of that, brought me proof, then I'd have some legal issue. But I don't have a legal issue because I have no proof in front of me. Okay, I have nothing to account for that. So I find by preponderance of the evidence that the plaintiff have made their case concerning possession of property for non-payment based on plaintiff's exhibit 1, 2, and 3, and the witness's testimony. Mr. Now, would 15 days suffice for the tenant to remove themselves?
Yes, Your Honor, 15 days would be sufficient. yes.
All right, so I am going to await an order from the plaintiff. So plaintiff proves their case by a preponderance of the evidence. A preponderance of the evidence after exhibits 1, 2, and 3 are admitted, and testimony of both the landlord and the daughter-in-law.
Daughter,
What's that?
daughter.
Daughter, thank you. And that's Alicia Wilkes.
Okay.
So by preponderance of the evidence, the order will be submitted by the plaintiff. And as of the date I sign it, there'll be 15 days from that date, okay? So if I sign it today, it'll be 15 days from that date. If I sign it tomorrow, it'll be 15 days from that date. So it'll be 15 days from the date of the court signing.
Your Honor, does the court have a form available to?
I
be
think
filled out?
there's one in the civil department, is there? I know there's one online, but
Okay.
I'm certain if you get it to the court today, this afternoon,
Okay.
by the time I get off the bench, I can sign it and it'll be, so I would plan on 15 days from today's date. By law, it's just 11. It's over 10 days. So 15 days, it says 15 days is extra time. All right, ma'am?
I understand, sir. I'm not disputing anything.
All right.
The only thing I wanted to know the 15 days for is because my daughter has to go out of state today and she won't be back until that 10 days is up, and she's gonna need that 5 days.
All right. So I'm going to return plaintiff's exhibits 1 and 2 to counsel. I'll return back plaintiff's exhibit 3, which is marked, but that's your driver's license. Is there anything else for the record, docket 2202930, Mr. Now?
I have nothing further, Your Honor. I will get a copy of a judgment of possession, have that prepared. I would ask Ms. Becker if she wants to stick around to take a look at it and approve it as to form before I submit it to the court. That'd be fine.
Okay, thank you.
Does that mean he cannot enter the?
He can enter it without you. He's doing it as a courtesy.
No, we're saying.
I'm talking about
until
right now.
15 days is up, he can't enter the house, all right?
No, you're allowed. It's your house for the next until 15 days after I sign the order.
He's walked in the house before without
Right.
permission. so I
As
can't-
long as there are tenants in the house, you can't walk in until you get possession in 15 days. All right, sir? All right. All right,
Thank
that's
you,
all
Your
for the record. Thank you, Mr. Now, and thank you, Ms. Becker, for your appearance. 2202930. Kesey, what case are you here on? You're gonna have to unmute yourself, ma'am. You're.
Okay, I'm on Brittany Lucero.
All right, all right. All right, well, let's go ahead and start that case. That case was scheduled earlier. We're trying to move some cases for the docket. So you can come up here.
Yes, sir.
All right. We're on the record in docket 2201381. And that is Brittany Weaver and Travis Winters versus Brittany Lucero. Will the parties please identify themselves for the record?
Brittany Weaver.
Okay, and sir, you are Travis Winters?
Yes, Your Honor.
All right. And ma'am, you are Brittany Lucero?
Yes, Your Honor.
All right. This is the time set for a hearing in this matter. And we scheduled it out for the purpose of, my understanding there were other hearings going on in Arkansas. Is that the state we're in?
Yes, it was adjourned.
Okay, it was adjourned.
Yes, for the custody case, yes.
All right. But this seems to be the remnants of a custody case on some level. I also wanted to take is Miss Kesey your witness, Miss Weaver?
Yeah, she is the process server.
Okay. And I asked for the process server to come and testify in regards, because I wasn't sure from K9 Process Services
Yes, sir.
that there was that Miss Lucero had been served for the show cause date. That was the defendant failed to appear. And what date was that?
The service was done September 10th, 2022.
September 10th, 2022. And you did serve Brittany Lucero at the residence of 807 Northeast Benton.
Yes, sir.
And that was in regard, and then there was a fail to appear after that, if I remember correctly.
Correct.
The fail to appear was on September 26th.
Correct.
And then we show caused him from there.
Correct.
All right. Miss Lucero, you indicated you were not served at that time. So my question for you is, we now have the service processor who indicates that you were served on that day. How do you respond to that?
Not true.
So you're indicating that the process server did not serve you on September 10th?
Yes, Your Honor.
All right. Well, we are all here now and we're going to have a hearing, all right?
Okay.
We're all here now and we're going to have a hearing in this regards. I find that you were served, you are here, and I'm going to start taking testimony regarding these proofs. We don't have any lawyers involved. So it's a preponderance standard in a civil case that comes from district court. Miss Weaver, are you ready to proceed today?
Yes, Your Honor.
All right. Mr. Winters, are you ready to proceed?
Yes, Your Honor.
All right. Can Miss Kesey be excused?
Yes.
All right. Miss Kesey, you're free to leave the Zoom courtroom. Thank you for your appearance.
Thank you, sir.
Okay. Miss Lucero, are you ready to proceed today?
Yes, Your Honor.
All right. Miss Weaver, you may call your first witness.
Travis Winters.
All right. So you're going to call Travis Winters. All right. And Mr. Winters, I'm going to have you unmute yourself.
Yes, Your Honor.
All right. I'm going to have you state your full name and spell your last name for the record.
Travis Winters, Winters.
All right. And raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth on a penalty of perjury?
Yes, Your Honor.
All right. What I'm going to do is allow Miss Weaver to ask you some questions in direct examination, and then Miss Lucero can ask you some questions on cross. All right, sir?
Yes, sir.
All right, Miss Weaver, you may proceed.
Mr. Winters, what is the reason we are suing Brittany in small claims or civil?
It started out in small claims, so.
Small claims.
But it's now been removed to district court.
Correct.
We are suing her because of damage and stolen property that Miss Lucero has taken.
Okay, I have the amount that's being requested at the maximum amount, which is $6,500. Is that correct?
Yes.
Yes, Your Honor.
I have in the file, there should be a list of items.
I've seen the list of items concerning that were attached to the original small claims complaint about various items. And if you want to, I can go through that for the record to make sure that the record indicates that those are the items you're suing that are the subject of the suit.
Yes, I do have a few other items that I can add.
All right, let me start. I have as a part that was attached the Kindle 10, a Kindle 10 with green case and Apple iPad, a PlayStation 5, a Ninja coffee maker, a PlayStation 4, a 75-inch Hisense TV, a Nintendo Switch console, a Unicorn Diamonds poster made for Paisley by plaintiff Travis, a dress bought for wedding for defendant and children and never worn, a Dino outfit my deceased mother grandma bought for granddaughter, an urn necklace with grandma's ashes that was broke during a DV incident, a baby Brezza, a sharp tie blanket made for Ivy, a tie-dye outfit for Paisley that was in memory of grandma, an Easter baskets made for the girls that I purchased, a Graco swing and bouncer bought by my grandmother, a jewelry box that was late grandmother's, Scentsy buddies for granddaughters, warmies for granddaughters, Arkansas Razorback blanket, and weighted blanket gray. You wanted to add to that list?
Yes, well, not add to it, but evidence that we have gotten, like the receipts of the items that were purchased.
You indicated all those items have already been purchased and been been in the custody of somebody else.
Correct.
Those are all used items.
Correct.
That's correct.
Correct.
Okay. So yeah, if you have receipts that you want me to look at, I'm happy to look at.
These are a few of the receipts.
Now, you're saying that you gave those and that those were stolen from you.
Correct. She was.
All right. So I'm going to have you ask Mr. Winters some questions about how those changed hands. So Mr. Winters, you can unmute yourself, and Miss Weaver can ask you questions concerning how those items changed hands.
Yes, Your Honor.
Travis, when were the items removed from Michigan? Or why were the items removed from Michigan?
The items were removed from Michigan because of the result of a DV incident, because I would not return the children to her after we have been going to court and no one demanded or told me I had to give the children back.
All right, so let me get this right. This is a custody battle, correct, Mr. Winters?
Yes, Your Honor.
All right, and you are the father of some children with Miss Lucero, is that correct?
Yes, Your Honor.
What are the names and dates of the children?
Paisley Kathina Winters.
Okay.
She was born
Paisley Winters, and what's her date of birth?
8/5 of 19.
8/5 of 19. So she would be 24 years old?
Why'd you say 19? 8/5 of 2019.
Oh, yeah, 2019.
8/5 of 2019.
Correct.
So that child would be roughly 4 years old?
3. She'll be 4 in
August?
Yes.
And that's Paisley?
Correct.
Yes, Your Honor.
And what is the second daughter's name?
Ivy Mae Winters, born 10/11 of 2020.
2020?
Yes.
And that's Ivy Winters?
Correct.
Yes.
And she would be 2 years old. She just turned 3.
2.
2. She just turned 2. All right. And were you and Miss Lucero married at any time?
No, Your Honor.
All right. But you're both parents of these 2 children. Is that correct?
Yes, Your Honor.
And then Miss Lucero left the state of Michigan and went to Arkansas. And that led to this small claims case. Is that correct?
Yes, Your Honor.
All right, you can continue with, I just want to make sure I got the names and you may proceed.
Travis, Mr. Winters, the items that have been purchased, who purchased them?
It was between me, my mother, and my deceased grandmother.
Where was a lot of the items purchased from?
Michigan and Arkansas.
Okay, so let me ask you this, Mr. Winters, how did they get into the how were they turned over? How were the items that were bought turned over to Miss Lucero?
Can I answer that?
When the whole incident happened, Miss Lucero and me, she decided to pack her stuff and move to Arkansas. And in the result, she took a lot of my belongings.
All right. So, and these were part of the belongings that she took to Arkansas.
Yes, Your Honor.
Correct.
All right.
The only item that we've gotten back.
Wait, hold on. Go ahead and talk to Mr. Winters. Do you have any more questions of Mr. Winters concerning, and you can piggyback any questions that I've asked.
Was there text messages made between you and Miss Lucero stating that she was going to return items such as the iPad, the Kindle, grandma's, the swing?
Yes, there was.
And I believe you have them text messages also.
I think they were attached to the complaint.
Did we ever receive, or Mr. Winters, did you ever receive a message from one of Brittany's ex-boyfriends stating that she sold your PS5 that you have a lease with through Aaron's Rental?
Yes.
Do we have did the gentleman send us a receipt with her signature on it?
Yes, he did.
And I believe you also have that. I have no further questions for him.
Ms. Lucero, do you have any questions of Mr. Winters?
Yes, I do.
All right. You may proceed with your cross-examination.
Thank you. Mr. Winters, where was the items purchased at?
Most of them were purchased in Michigan and Arkansas.
What was purchased in Michigan?
The Dino outfit, the PlayStation. I can't remember exactly what all was purchased in Michigan.
I can answer that.
When you take the stand, you'll be able to, yes.
What was purchased in the state of Arkansas?
There was a TV, PlayStation 4, a Nintendo Switch, and I believe that is it.
Okay. That's all the questions I have, Your Honor.
All right. Thank you, Ms. Lucero. Ms. Weaver, did you want to testify today?
I can.
All right. It's up to you. It's your case.
That's fine.
All right. So I'm going to have you testify from exactly where you are. You don't have any further questions for Mr. Winters?
No.
All right. So Mr. Winters, you're excused as a witness. You can stay as a party. Ms. Weaver, I'm going to have you state your name and spell your last name.
Brittany Weaver, W-E-A-V-E-R.
All right. And I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right. You may proceed. You can make a statement in regards to your case.
So I guess the biggest statement is a lot of these items were items that I had purchased for the grandchildren. And I would like them back so when my son has visits with them, he can have them. The iPad.
So let me just get this right. You purchased them for the grandchildren, and now that they're not together, you only want the children to see those items when your son sees those items.
When they're with their father, yes.
Okay. So did you actually purchase them for the grandchildren, or did you purchase them for Mr. Winters?
Both, I guess.
Okay. All right, just clarifying. Okay.
There are items that, of course, I don't have receipts for that were bought by my deceased mother.
Right. And you understand, I can't give you any damages for sentimentality.
Right.
It's what a buying seller will give a buying buyer for a used item.
Okay.
That's what you get today. Okay. You don't, if you want something else, you got to go to a different court. Because what I'm going to give you is I don't give you sentimental value unless you provide me with some expert to tell me that. Okay. All right, continue.
I believe I gave you receipts for everything that you would need.
All right. there's some pictures here I've not, that were brought to the court's attention, because I know we've done a lot of through Zoom on July 8th. Did you want the court to look at those photos?
I don't know what photos they are.
All right. I've not looked at them. Ms. Lucero, did you provide the court with any photographs for the court to look at?
I provided bank statements to Nathaniel. He received them.
Right.
I never received
Yeah.
that statement.
Okay. All right. Ms. Weaver, do you have any further proofs?
No, Your Honor.
All right. Ms. Lucero, do you have any proofs to, I mean, do you have any, so does the plaintiff rest in this matter?
Yes, Your Honor.
All right. Ms. Lucero, do you have any proofs in this case?
Just a bank statement. I don't know. I have all the items in my house. That's correct.
All right. Did you want to make a statement today? I'll swear you in and you can say something under oath.
Yeah, I can do that.
All right. So please state your name and spell your last name for the record, and that's really for recording purposes.
Okay. Brittany Lucero, Lucero.
Okay. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, Ms. Lucero, why don't you make any statement you'd like to make to me, and then I'm going to subject you to cross-examination of Ms. Weaver on the statement you make. But go ahead and make any statement you'd like to make concerning, and I guess what I'm really interested in is how did these items get in your possession? And then there's a small claims based on the amount for the items. I guess that's what I'm looking at, and I guess that's what I'm most interested in.
Okay. I moved to the state of Michigan of 2021 of October due to the fact that me and Mr. Winters were reconciling together for the custody case of the children. I did purchase the TV, the 75-inch TV in the state of Arkansas, along with the stuff that I have. His mother did purchase some outfits for the kids when they were born. And that she also purchased some outfits as Paisley was getting older. Unfortunately, I did leave the state of Michigan of January 14th. They filed the small claims when I got back into the state of Arkansas, but everything I left for them was inside that apartment in Michigan. I did take my 75-inch TV. I did take my bed that I own. I did take my kids' stuff because that was my kids' things. The tablet I did take due to the fact that it's underneath my Amazon account. We just traded it in to get a bigger tablet for her. And unfortunately, Paisley does use it at my house. And I purchased Ivy a tablet with my own money for the Amazon account as well. I did have the PS4, which I purchased in 2020. As you can see, if you have the bank statements, I did purchase it in 2020 with my Lily card. And then that was the pandemic money. And then when me and Travis split twice, one was in 2021 and the other one was in 2022. And fortunately, Travis didn't want any of the items of the home in 2021 when he picked up and left his dad's in the state of Arkansas. But now I don't understand is that when we split of 2022, they want to sue me for all these items when Travis knows in his heart that I have purchased some of the items as well.
All right, Ms. Lucero, is there anything else you'd like to say to the court?
No, Your Honor.
All right. Ms. Weaver, you have any questions of Ms. Lucero?
No, Your Honor.
Okay. All right. No cross-examination of Ms. Lucero. Ms. Lucero, do you have any further proofs today?
No, Your Honor.
All right. Does the defense rest? Ms. Lucero, you broke up there for a little bit. Does the defense rest in this case?
Yes.
Okay. Ms. Weaver, summation?
I I guess I would personally like the property back versus the money. That's I would rather have the property back. There's items that we're still paying for, or that, I'm sorry, Mr. Winters is still paying for, that she has sold. I just don't think that's fair. And there's items that she took that she knew were sentimental value. She knew that they meant something to us and that we wanted them back because they were going to be handed down to other grandchildren. I just think what she did was wrong.
Ms. Lucero, do you have any summation for the court to hear before the court passes sentence? Or before the court indicates a decision in this case?
Yes, I do, Your Honor. The stuff that is in my house, I don't have a PS5 in my house. I left it in the state of Michigan, outside of the front porch, actually, when it was snowing. I did not take that. The reason why there was a statement of saying it was my signature is because the people that Travis was talking to was setting him up. And the items that you would want back of clothing or whatever, I have to go through a lot of things with my stuff, of the kids' items, because there is stuff that Ivy still wears because Paisley is passing it down to Ivy of the clothing. So yes, I want other things back. I don't know what other things you would want back. When
All right.
Ivy wears clothes.
But I've read this file several times, and I could not be more disappointed by the adults in this file. You came to a hearing, and that's what you're here for. So I'm going to tell you, the only truest victims in all this are the children. I don't believe that. I don't believe you can give something to a child and take it back, explaining to the child that you should only get it at a certain time on a certain date. The child doesn't get that. The child doesn't understand that in any way. The child just knows that they don't have it anymore. And if that's the manipulation we're using as adults, then this is really, really sad. So we've come to a really, really sad place here. Okay. The pettiness involved, fighting over stuff when there are genuine children involved. It breaks my heart. It really does. I can't tell you how dismayed I am by this. This is a custody issue in small claims court and district court. This is a custody issue. They can adjourn all the matters they want in custody issues in Arkansas, but I'm ending this today. All right. I'm indicating that today you have not met your burden and preponderance of the evidence. Okay, you have not met your burden. I'm gonna start with a clean slate here. Mr. Winters and Miss Weaver, you do not get any that you're asking of the $6,500 of the receipts and everything, because I don't believe you've proven that this was taken from you. I think half this stuff you'd be taking from children. And I don't find that reasonable in any way, under any circumstances. Ms. Lucero, you do not come out of this empty-handed here. You do not come out of this clean. Okay, these children are victims of adults' mismanagement and misbehavior. And there's a sadness to that that's so great. But for this district court purpose, I only have one ruling, and that is that the plaintiff had not proved their case by a preponderance of the evidence in the small claims matter, and therefore the case is dismissed. And that's all I have to say on this. All right. You may follow up with an order if you choose. If you choose not, but the case is dismissed.
Okay.
All right. So there she is. All right.
I'm
All right,
sorry,
Ms.
I didn't-
Quiroga, I'm gonna call the case of 2202-947. That is SJ Commercial Property versus Linda Quiroga. Will the parties please introduce themselves for the record?
Joy Whitty on behalf of plaintiff landlord, Your Honor.
And ma'am?
Rita Dunlap on behalf of SJ Commercial Properties Partnership.
All right, thank you. And you are Linda Quiroga?
Linda Quiroga.
Okay, and you can hear me all right, Ms. Quiroga?
Yes, I can, Your Honor.
All right, Ms. Whitty, you had the chance to meet with Ms. Quiroga in a breakout room?
Yes,
Okay.
we met. We did not resolve all issues. I did try to make it plain to her that rent goes up after the complaint, so it was higher than she expected. I did try to explain to her that a landlord will tell a tenant, don't pay me rent, we're in litigation. That seemed to upset her, but I explained that is how that works. They had some complaints about the apartment. And my client basically said if they could pay some rent, I could do those minor repairs.
Okay.
So that's where we are.
So, did you want to start proofs today, or did you want to, does your client want to see if they make those repairs? I guess I'm kind of leaving it because your client knows the status. This is set for formal hearing.
Yes.
We'd have to reset the formal hearing.
I think we should proceed today.
Proceed. I'm gonna do the repairs. I just put a new toilet in. I'm gonna get a
Right.
new refrigerator.
So we have a
Yeah.
second item that's come up, and that is if we're taking testimony, we do have an incidental relationship between my court recorder and so I want to disclose that, okay? So my court recorder is a step niece.
A niece right now.
Yeah, a step niece, all right. And so I don't think that would have any bearing on objectivity in the case, especially my objectivity in the case. It certainly is not required by any blood rule that we would be set parameters, but I want to disclose that, all right? Ms. Quiroga, you understand that? There's a shirt tail relative relationship between my court recorder and the property manager. If you have an objection to it, this is the time to make that objection, and then I'll make a ruling on it.
That's everything as you're saying. That's her
So
niece.
do you have an objection to that, to us proceeding today?
No, Your Honor.
All right. Then, Ms. Whitty, I'll have you call your first witness in regard to this file.
Your Honor, we would call Rita Dunlap.
All right. In the meantime, let's see. You were supposed to meet with Mr. Landon, correct?
Yes.
And so let's put him on the iPad to meet with Mr. Landon.
Your Honor,
Just so we
may I
have
have my
something going
client?
on while we've got proofs going on. So, Mr. Landon, are you still amenable to meet with the tenant in your case now that we
Yes.
have an iPad available?
Can I have my property manager join us, Your Honor?
Sure, and that is
Pandora.
Is that okay? So, Miss Noy, Pandora Noy.
Kanoy, yep.
All right.
Yes.
Let us get that all set up. So, sir, you'll follow my court officer. And then he'll come back and set everybody in the rooms they're supposed to be in. Ma'am, why don't you come up here, state your first name and your last name and spell your last name.
Rita, R-I-T-A, and Dunlop, D-U-N-L-O-P.
Okay, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay, please have a seat right here. Please project for audio purposes. We're recording it. And Miss Whitty, you may proceed.
Thank you, Your Honor. Can you state your business title with regard to the plaintiff?
I'm everything. I'm a handy woman, the manager, the landlord, fix things, pretty much everything.
Thank you. And are you familiar with the books and records for this address, which is 5724 Richwood Street, apartment 103 in Lansing?
Yes, but my partner does the ledger. I can do them, but he does them as a.
Thank you. Did the defendants enter a lease with you for this property?
Yes, they did.
Your Honor, you would have a copy of the lease attached to the complaint.
We do.
And if you would like to have it marked, otherwise we'll simply recognize it.
I think we can just recognize it because pursuant to statute, it has to be made as a part of the complaint. And I do believe we have a copy of the lease. Yes.
Ms. Dunlop, did you file a notice to quit based on non-payment of rent? Did you do that on August 5, 2022? And Your Honor, of course, that's also part of the court's file.
Okay, and that just in regard, that is that it was on August 5th, 2022, and there was service made on that demand for possession and notice to quit.
Thank you, Your Honor. Are the tenants currently in arrears in the amount of $8,060? And do you understand court costs to be $240.19? Are you asking the court for a total possession judgment of $8,300.19?
Yes.
And are you also asking the court for a money judgment?
Yes.
And do you understand that a money judgment currently totals $7,876.77? And
Yes.
Is that a yes? Okay,
Yes,
thank you.
I didn't know if it was finished.
that's okay. And with the same court cost, do you understand the total money judgment being requested is $8,116.96?
Yes.
And was the property kept fit for the use intended, that of a residential dwelling?
I feel it was.
Thank you, Your Honor. I have no further questions.
Just for the record, what was the court cost again, that number?
Sure, $240.19.
All right,
I have a judgment form at that
all right.
filled out.
Ms. Quiroga, do you have any questions of the property manager at this time?
Yes, I do. We were
All right,
never
so you may.
informed. I'm sorry.
So go ahead. Just make sure it's in the form of a question.
Okay, Rita, can I question her or how do I do this? I've never done this before.
Just the witness, just the witness.
Okay. I have a question. Why didn't Rita send us a letter saying how much the amount was due now?
Right, so she's asked.
I mailed some ledgers out. I can check my dates. I mailed them out, but the reason why you're confused is rent keeps occurring. Even though the date is August, you're still living there and during this time, and that's why the balance is higher.
Okay, I have another question. Why was it that you kept on, I'm sorry, Your Honor. Why was it that you kept on telling us every time we asked you, do we pay you rent? You would always tell us to get help from programs rather than.
Go ahead, I'm sorry.
Rather than us paying you rent.
When we were involved in the SARA programs, and which sure many have, I asked them and they said for the tenants not to pay the rent during that period, and they were going to advance them another 3 months. So my tenants didn't pay during the SARA programs. Now, the issue we ran into after that is when the date was up, unfortunately, you had exhausted your benefits before their date was up. So then you owed again. But at that point, you didn't offer to pay. I said, try to get help from agencies, from DHS in these places, but nothing occurred. So that may have been the confusion. And now, once I was in litigation, am I correct not to take payment?
Okay. Okay, you were the one that told us not to pay. And you were the one who helped us fill out the forms for the rental and that. And you were the one who dropped off the paper. Am I correct?
You asked me to, the thing with DHS is we can't get any of my tenants out unless they get denied by DHS. They have to fill out the form, and all I do, if they want me to, is I just drop it in the drop box. Or they can mail it in, but the problem is the mailing, takes time. But I do that not just for you, Linda, but others too. If they want me to drop it in the drop box, I do.
Okay, yeah,
And
you were the
told me
one.
got confirmation about it.
Okay, you helped me fill out the form, remember? Because I told you I didn't know how to
Yes.
do all that.
About the Sarah form.
Yes.
Was it the Sarah? Yes, correct.
Okay, you helped me fill out the form for Sarah and for the DH.
Correct.
And I asked you, because we didn't have a vehicle at the time, if you could drop it off for me. You said, yes, it's
Yes.
no problem. And then we never heard from our caseworker and this and that. And we were trying to get, I would ask Sierra program, what was the, what was, what did I tell him? What was, going on with our case and that. And they would tell us that,
Right, ma'am,
they're
that
working on-
you're gonna have the opportunity to make a statement in this case. That sounds like much more, that doesn't sound like a question to me.
Okay, well, I'm sorry, Rita.
So do you have any further questions for the property manager before you make a statement on your own?
Okay, I do have a question for her.
Okay,
Rita, when you called us and told us you were gonna come and fix the rest of the stuff in the house, you said you were gonna come Friday, correct?
That is correct, but I did not make it. I thought I notified you.
No,
I'm
you did
planning
not
on
call
doing
us
more,
back.
and I did fix the toilet. Yes, I put a new one in.
Yes, and you told us after you left, you told us you were gonna come back, fix the doors,
Yes.
do the filter, and something with our refrigerator.
and
You were
what
gonna get us
date,
a new
what,
refrigerator.
Ms.
This
Kroger,
was
what
just-
date was that?
It was either Wednesday or Thursday of last
Okay,
week,
so within the last week, okay.
But it's been an ongoing thing.
but it's been going on rarely with her. We always
Okay.
have to complain about something, and she always tells us, we'll get to it, we'll
Couldn't go
get to
outside
it.
and-
Who's we? She don't have no handyman. That's why we
All right.
always have to wait on things, because she doesn't have nobody to help her.
All right, do you have any further questions before you make a statement, ma'am?
Yes, I want to know if we can do a agreement on payments. Like we were before.
I think that, Ms. Kroger, I think that ship has passed. I think we're already in a hearing, so there are no, this is a contested hearing now, so I don't think we can do agreements anymore.
We were doing that before, and she put a
Right.
stop to it, because she
Right,
wanted
we're
us to
done.
go to the programs.
Yeah, Ms.
We wouldn't
Kroger,
have everything caught up at the time.
Ms. Kroger, there are no, this is a hearing. Ask her questions. There's no more agreements. Do you have any further questions for the witness?
No,
All right, may this witness be excused?
Certainly. Your Honor.
Without objection, the witness is excused. Ms. Whitty, do you have any further proofs?
I do not.
All right. Ms. Kroger, do you have any proofs today? Would you like to make a statement?
all I want, I mean, we like the place that we're staying at. All we just wanted was our.
Okay, so let me swear you in and you'll say it under oath, ma'am.
Okay,
So the name is Linda Quiroga. It's Linda Quiroga. I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
yes, I do.
All right, go ahead. Now make your statement, ma'am. You're under oath and on the record.
Okay. All we always asked our landlord was to fix things in our home. And there was times that she would work with us and that we were doing payments when she was accusing us of not paying rent. We had all our receipts. This was back when we first moved in here. And excuse me if I get emotion, but I mean, I'm a 54-year-old woman trying to keep a good home for my child, my boyfriend. And it's like she never does anything hardly. She always puts us aside. She does everybody else, but not us. And we get tired of that, you know? We're trying to do good for us. We stay by ourselves. We never get into anybody's business. When our neighbor downstairs in apartment 98 was always harassing us and that, and we would call her and tell her what she did to my daughter and this and that. And we would call the police. The police always said, talk to your landlord. So we did. And Rita would always say, oh, I'm going to do something about it. I'm getting her out of here. Well, the lady is still here and she still harasses us. And she hasn't done nothing. She says, I'm going to put cameras in. Where are the cameras? You know, I mean, we're willing to work with Rita. We've never done her wrong in that. So I don't know why she's treating us so badly when we just looking for a good home to live.
Ms. Quiroga, do you have any other statements for the court?
Yes, I'm diabetic. I have issues, and she knows that. And we live up in this apartment. He's crippled from his legs from accidents and that. We get tired. We can't even walk up the stairs. We've asked her if she can give us a bottom apartment, and she said, and I quote, she said that when we paid the first payment, she would move us downstairs and that. Well, she rented it out to somebody else and never did it for us. She helps everybody else but us. She always puts new carpets in, new appliances. What about us? What is it that you have in for us, Rita? We've done you nothing wrong, and we treated you so nice in that. You say nice things about my grandkids, that you love them in that, and this is how you're gonna treat us? You know, I'm just trying to make a good living for my son, my fiance, and this and that, and you're treating us bad.
All right, so that'll conclude the statement from Ms. Quiroga. Do you have any further proofs today, Ms. Quiroga?
I've written down what all needs to be done.
All right. You didn't appear in person, and I have a live in-person requirement.
Okay, I didn't know.
I actually have it written here, live in-person hearing.
I don't remember seeing that. I'm sorry.
That
Okay.
was set at the last December 14th pretrial, which is why that's why the plaintiffs are here.
There's nothing on this paperwork saying that.
On the last paper that you sent me, Your Honor, it doesn't say in person on that one.
I'm talking about what I actually said in court on the record.
Oh, okay. I'm sorry. I'm sorry. I probably didn't hear. I'm deaf in one ear, so I'm sorry.
All right. Do you have any further proofs today, Ms. Quiroga?
Just what we need, but I mean, just what needs to be done in the home that we reported so many times.
All right. Do you have any further proofs?
No, Your Honor.
All right. Defense rests. Any summation from the plaintiff?
Only, Your Honor, that there seems to be no dispute about the amount of rent that's owed.
Well, from a legal standpoint, this is a real clear-cut case. Okay, the plaintiff have met their burden by a preponderance of the evidence. It is hard for me to take. That's why we have live hearings. It's hard for me to take any exhibits and do a hearing in person by Zoom. But there is a lease here. There is a notice. There's a notice of eviction. There seems to be no debate that there's arrears in rent for at least 5 months. And so all the boxes have been checked. It appears to be habitable. So it appears to be habitable, so habitable that the defendants continue to want to stay there and also continue to want to agree to make payments there. So it tells me the habitability may be a concern, but it's not a legal issue in this matter. Therefore, I believe by a preponderance of the evidence, the plaintiffs have made their case. Their case by preponderance of the evidence. Of evidence. You've stated your numbers for the record. I've written them down. Do you have an order for the court to sign today?
If I may approach.
I will sign an order to that effect. And this has the February 2nd, 2023 date on it. If there's a need for some workaround, I'm sure the landlord would be willing to look at that and make some accommodations. There's a February 2nd date, and I'm signing it today.
It's 10 days.
Your Honor, we've been calling the agencies that are on the court hearing paper, and we got a hold of what, 2 or 3 of them, and we left our phone numbers so that way they can call us back. And we will go to DHS and get a rental information form to fill out.
Okay,
I did
ma'am,
mention
we're a
that-
little further than that. I've just signed an order of eviction. So that can be enforced on the February 2nd date, February 2nd. Of course, some accommodations can be made in regards to whether the date and time that you can move out, etc. But the ruling of the court is that the landlord has proven their case by preponderance of the evidence based on a lease, based on a notice, and based on the fail to pay and arrears.
But that was not our fault, Your Honor. She was the one who
I know,
kept on
I know,
telling us not
I
to
know.
pay.
The law doesn't look, ma'am, the law doesn't look at it fault wise. The law just looks at whether the landlord has the money. So, and it appears that there was Sarah involved at some point in time, and after at some point in time, that was not helpful. So, anything else, Ms. Whitty, in docket 2202-947?
No, thank you.
All right. Ms. Quiroga, you're free to leave the Zoom courtroom. This hearing is finished. You can provide that to if they want a copy of it.
Like, 10 days, you got till February 2nd.